All right, we are live. Hey everyone, welcome to another edition of live streams on Legalbytes. I have with me this week, I have Uncivil Law, and I have Nate the Lawyer, and Good Logic. So say hi, guys.
Hey,
Hello.
good
What
logic.
up?
You're up here in New York. Did you get flooded? The flood issue like we had?
My basement right now. So when I moved into this house, they explained. I had no idea about this, but apparently, the water when there's hard rain for like a few hours, so the ground becomes saturated with water, and the water sinks below the level of the house, and then starts coming up through the foundation, through cement, because cement is porous. And it'll start seeping up in the middle of my basement. It'll just start coming up through in my laundry room. And we have 2 inches of water in my basement. In fact, the wife was like, "You need to spend all day helping me today." I was like, "Are you kidding me? Legalbytes like made this stream for me, and how will they? How am I gonna like?" I was like, "I can't do that." So
Oh,
yeah,
well, I appreciate you being here.
yeah. When this stream ends, I'm basically gonna be rolling up my pants and walking down there and.
Oh my God.
I mean, it's
And
only
just,
2 inches
like,
deep.
Setting
so
up a
it's-
canoe and just rafting.
When I was a kid, we lived at the bottom of 3 hills, and we would get in our basement 4 feet of water. That was something. This is like a probably a 5-hour job. That was like a 3-week job to like clean up that mess.
Wow.
So
And it's funny because I had when I woke up first we got a message from the school. School's closed. It was like 4 a.m. I was like 4 a.m. They sending us a message. I'm about to yell at the school, but then I looked outside. I was like, well, let me see if I can at least move the car. And I looked outside, and the whole street was just like a river. I was like, fuck, there's no way it's gonna happen.
Oh no. Oh,
but that's
no.
part of the blessing of 2020 is that now your kids at least get some schooling and that they're being homeschooled. In the old days, there would be no such thing as a Zoom class, and now it's like, all right, I guess we'll do it this way. It's not. It's like
Going back to remote.
it's not that big. It's not that big a deal as far as interrupting their learning, assuming they actually learn anything on Zoom, which that's another question. But
That is fair too. So, ooh, thank you. Just got a drink handed to me.
yeah, you always. I
Non-alcoholic,
notice
don't worry.
you often have
try
like a
that.
mysterious hand stick into your thing, handing you stuff.
Yes, it's a disembodied hand that hands me
It's-
drinks and kittens.
I gotta get me a thing. I have to get thing from the Addams family to like be bringing me like just like doing that sort of thing. It's great.
So everyone on my channel should be familiar with Uncivil Law and with Nate the Lawyer at this point. But Good Logic, just give us a really quick, intro on your background, and then we'll get into some of these hot topics that we've got for this week.
All right, so my name is Joe Neerman. My channel is called Good Logic. I have my locals, which you see up there, goodlogic.locals.com. I am a New York litigator and turned YouTube content provider. I talk law, I talk politics, and I stream nightly from 10 p.m. till midnight Eastern. And I'll include some philosophy where I'll sort of I'll interact with my viewers, and we'll talk about things like, is it right to sink to the level of your opponents when they engage in terrorism in order to protect your people? And sort of try to make them think about things from a new perspective. So
Yeah, and it really interesting stuff. I remember when I was on your channel, I think the question was, it was like, which of the 7 deadly sins is the worst? That was a really interesting discussion.
Yeah, it's not always about law and politics. Frequently, I'll just branch into something just about. I call it my humanities section. So I'll just sort of, I like analyzing, understanding people and how they think and societies and how they approach things and differences in different cultures, and that's my favorite part of the show because I get to actually engage my audience. I'll spend a lot of time just reading off their comments and just sort of, thinking through things through with them. So
Yeah. Awesome. So if anybody who's watching this, if you haven't already, check out Uncivil Law, check out Nate the Lawyer, check out Good Logic. Good Logic, is your YouTube channel back up yet or no?
Thank God. Yes, I had
good.
I had been suspended. I got suspended a week ago, 9 days ago, because
Talking about the Fauci juice.
I wasn't going to mess up your stream, right? I was talking about. I was specifically about laws and rationality of laws regarded to those 2 words, and I'm scared to even say those words in a sentence. Just say this because I've gotten a warning and a strike for that, only for that one topic. 2 different streams,
Yikes.
different times. Back in April, I got a warning, and then last week I got a strike. So, yeah, look, if I'm going to stay on, if I'm going to be able to communicate with people, I think that's like one topic that it's just like, no. So,
Yeah.
what am I going to do?
Yeah. So, but glad to hear that everything's back up and up and running. So awesome. So let's get to these topics. I set up 3 main topics, and we can talk about which one do we want to talk about first? We can probably actually, you know what? Let's get into the Texas SB8 law first, because I think that's one that is probably the hottest right now because it's very, very, very recent. So for anyone that doesn't know, Texas this week signed into law a new law on termination of pregnancies. We can say, I don't know if that word will get the stream demonetized. Most likely this will get demonetized anyway, but you know. But so a new law that basically targets termination of pregnancies before a certain point. So basically it says that it imposes civil liability on anyone performing a termination after the point at which there is a fetal heartbeat, that they can detect one. So for anyone that performs one or aids or abets one, so including people that pay for one. So this is civil liability. It's not criminal liability. No one's going to jail over it, but there's they can get injunctive relief, meaning that they can get a court to tell them to not do it. And they can also get penalties no less than $10,000 per act. So this is a really interesting new law. As soon as it was signed into law, there was somebody filed an emergency appeal to the Supreme Court. Then the Supreme Court eventually decided that they were not going to grant the emergency appeal. So there's no stay on that law. So currently this law is active, and there are a lot of thoughts and a lot of emotion and a lot of opinions on this law. Let's put it that way. So what are your guys' thoughts on this?
Morally or legally, are you asking us?
I mean, I guess let's maybe stick to legally, at least for now anyway. I mean, whatever. If you guys want to add your own opinions too. I think for me, I prefer to stick to the legal analysis for this. It's, to me, like, it's very, very intellectually interesting because it's so different from what we have seen in the past for this kind of subject. So I don't know. On civil law, you're in Texas, so why don't we start with you?
Well, I've done a couple of videos on SB8 and the structure of it, whether or not it will ultimately be successful, but what they're trying to do, in my opinion, from a legal perspective, is genius. So normally what you do when you're trying to have a law enforced, you normally give some sort of state authority the power to enforce it, the attorney general, your prosecutor, someone like that. So if there's a law planning to go into effect that you don't want to be enforced against you, what you do is you file a preemption challenge. So you sue the, say, attorney general, and you say, hey, attorney general, you can't enforce this law against me. There's a sufficient enough threat in the future that I can satisfy standing. You can get there. And you can't enforce this law against me, so it's an invalid law. And what made SB8 different is they stripped all the state authority of all power to do stuff. So you can't pull that trick. You can't go into court and say, Attorney General, you can't enforce this law, because the Attorney General will just turn right around and say, you're right, I can't. There's nowhere else to go. It's all private mechanisms. Essentially, what Texas did is made everyone a private Attorney General. So anyone can bring a lawsuit to enforce this law, except for a state official of some variety. So they're trying to prevent that. And you saw the analysis in the district court, which I found wanting for various reasons, basically saying, well, if they can't sue them, then there's no one they can sue, and they must be able to sue somebody. But that's what they're trying to do, is create this purely private enforcement mechanism. So there's basically no constitutional issues that apply, because the Constitution doesn't apply to private persons. They're not being directed to do it by the state, so they're not state actors, is the idea. That's how they're trying to get around it legally. And the Fifth Circuit Court of Appeals stayed all proceedings in the district court. the district court found that there was jurisdiction. It found there was a federal question. The Fifth Circuit basically disagreed, stayed all proceedings in the district court, including a finding on constitutionality, while they tried to resolve some legal issues themselves. So it's very interesting how this has panned out legally so far.
Yeah. Yeah.
And following up on that, the Supreme Court actually came down 5-4 within like the last 10 hours, I think, or something, saying
Right.
saying that they're not going to offer injunctive relief. Now, the four against were predictable in that it was Kagan, Sotomayor, Breyer, and Roberts joining in in his rhino way with the with the dissenters, and the other five basically said they specifically punted in the short term for determining the constitutionality of the law. What they said is that they embraced Uncivil's perspective on this, saying that the whole question as to the parties that you're naming here shows a lack of likelihood of success on the merits. In order for you to succeed in injunctive relief, you have to show that there's irreparable harm. You have to show that you have a likelihood of success on the merits, and also balancing of equities. So irreparable harm, that you could say probably exists here. That means it's not something that can be fixed by just paying people money. So arguably you can say that the $10,000 fine, which may be applied, that's not really what this is about. So you can say there's going to be irreparable harm here, and that people are going to have life-altering things that are going to happen, that they're not going to be able to get an abortion. With respect to the question of success in the merits, though, the court balancing of equities means what's fairest. And a lot of times they'll go the status quo, which is why in the dissent, Chief Justice Roberts focused on the status quo. He's like, I would give the injunction just for the purpose of the status quo and maintain the status quo until we can figure out what the appropriate law is here. Because understand that injunctive relief is basically saying what law will be guiding us until we come to an ultimate decision here. And he's like, let's maintain the status quo. The majority said, you don't have a likelihood of success because, as Kurt just pointed out, it's hard for us to understand why these parties are even brought here when they say specifically that they have no intention of executing the law. If they're not going to be they're not the ones executing the law, they are not the proper named defendants. So you're unlikely to prevail in basically saying that you should beat this guy and stop him from enforcing the law when he's signed a sworn affidavit saying, I'm not going to be enforcing this law. I'm not doing anything with this. So if he's not the proper defendant in that case, you're not going to win. You don't have a high likelihood of success, so we're not going to give you the injunctive relief, and that's why we'll allow the law to remain in effect while this case is being pending for its other issues. But they specifically said we're not judging the constitutionality of the law.
Right. Yeah, they did say in there, and it was a very short majority opinion too. They said that they were not ruling, like nothing that they were saying in that opinion had any impact or any indication as to how they would rule on the issue of jurisdiction, or on the issue, or I think standing, or on the issue of the substantive issues themselves as to whether or not it's constitutional. So, Nate, what are your thoughts?
There's a lot going on here because there is a lot of state action going on here, and I think that can't be ignored. Hold on one second. I gotta log in back for my kid.
Okay. Yeah. I mean, one of my first thoughts though is that, so the court said that the state doesn't have any enforcement powers under this law. However, my big question then is who has standing to sue under this law? Because you're saying that any guy off the street can sue a woman who goes into Planned Parenthood, any guy or any woman, that has no other relationship other than seeing that they've gone in there and then, suing to find out, because obviously you don't necessarily need to know for a fact that someone has done something wrong in order to file a lawsuit against them, especially a civil lawsuit. All kinds of information comes out during civil discovery, and ostensibly, then that would mean that somebody who just happens to sue under this law has the ability to access a woman's medical records, just because. So I have concerns on that level under this law because of the question of who is able to sue.
Yeah, no, I mean they're trying to preempt all that. I don't know who dreamed this up in SB8, because I couldn't dream this up in my wildest dreams. I went through it in detail. I was like, I don't know who came up with this, because they tried to think of everything to try to work around all the normal problems. I particularly love their how to read this law if you're going to strike parts of it down, or how to interpret the law, because they have this whole huge section on here's exactly how we want you to interpret the law, courts, as you're trying to figure this out. Severability. We want to sever every provision from every paragraph, from every sentence, from every word. We would have passed this law. Just so you're clear, we would have passed this law without that paragraph, sentence, word, section, as the case may be. So don't worry about that. Also, incidentally, you're not rewriting your law, so you can't complain about that. And they just try to think of every possible mechanism the courts have. And then they also, which I've never heard of such a thing before, they ended non-mutual issue preclusion. So to put it another way, they basically made every decision on this non-precedential. That's another way of putting it. So if person A sues the abortion clinic and loses, person B can sue the abortion clinic for the exact same thing, because basically we turned every case non-precedential. There's non-mutual issue preclusion, non-mutual judgments, and there's a one-way fee-shifting statute. So if the person suing loses, they don't have to pay, but if the abortion clinics, they have to pay. Injunctive relief, it's brutal. And has been pointed out in the chat, regardless of what you think about the abortion issue, if the logic of it holds, then presumably some not particularly creative politician can modify it to apply to, say, for example, gun rights or free speech rights or anything else. It's not us trying to suppress the guns. It's the hippies, as the case may be. So I don't know if the people who created SB8 thought that far ahead or just didn't care. But it's like you've created a monster, and this can be used against you very trivially if it works.
Yeah.
I think that's so true. Like when I first saw this, I just started thinking free speech, right? Because there are laws like this when they pass a law, something like this, or regulation that has the ability, the ability to quash speech, right? Or to detrimentally make people feel like they can't say something, or there'll be this penalty against you. That's unconstitutional. And when you talk about religion, when you talk about gun rights, as Kurt just said, this can apply to all of those other things. And I understand them trying to get around Roe v. Wade in the civil matter, but there is state action here, right? The state that's passed the law is giving people the right not only to sue, but also have injunctive relief. So it reminds me, what was the case? The case with the housing when they didn't allow black people to
redlining
the racial covenant. The racial covenant case for the Supreme Court, where there was like two private parties, but then the court said, well, even if you private parties have to go to the court to get a racially restrictive covenant enforced,
to enforce it,
then that was also state action. So you can't say this private party thing doesn't matter, because you're actually, the state has a role in it by passing this law, and I think exactly what's going on here. But I do like the creativity of it, though, because I'm a legal nerd, so I like the creativity of it, and I love the way they're trying to maneuver around the criminal aspect of it, because obviously that's the thing that's been being struck down. But I also think pushing this back and trying to narrow the Roe v. Wade to the heartbeat, I think is actually an ingenious way to restrict the law even further if you're someone who's pro-abortion. Yeah, he's right, Shelley V. Kramer.
There we go.
Thanks, Legal Mindset.
Thanks, Legal Mindset.
Yeah, you have
better than all of us.
Any attorney who saw the construction of the statute had to be awed by the inspiration of it. And I think there's really three parts. You have, as far as just using financial instead of using criminal, that's circumvention here. That, I think the inspiration for that is we've seen how the federal government, under the 10th Amendment, they're restricted from being able to intervene in how states operate. So what do? They hold a financial carrot out there, and they basically say, okay, fine, we want to change the national drinking age minimum drinking age to 21. You guys all have it at 18, so we're not going to give you any money for your roads until you to any state that doesn't have a minimum drinking age of 21. And all the states rely on federal government for funding for their infrastructure. So they say, oh, okay, fine, I guess we'll raise it to 21. So what are they doing? The federal government wants to violate the Constitution. They want to violate they want to ignore the 10th Amendment. So they basically use the financial carrot or financial stick, as it were, and direct states what it is that they have to do. And essentially, what they're sort of I think the inspiration for this law is they're sort of saying, okay, how can we circumvent the whole constitutionality of Roe v. Wade? We know if we just write a law like this, it's going to be struck down, but we can use money and the threat of potential damages as a way of ignoring the Constitution. And we'll say, now we'll have private citizens basically suing everyone under the sun because they're going to be chasing their nut of getting $10,000. And any before that even happens, abortion clinics and everyone knows that, hey, I can be sued left and right anytime I commit any procedure at all. So they're just voluntarily shutting down, like the states voluntarily bring themselves to the 21 minimum age for drinking. So too, these abortion clinics are gonna bow to the power of the dollar, and they're ultimately gonna say, I can't operate here in Texas. So that's the genius behind it. I think the severability of it is also that's just good draftsmanship by any lawyer who basically has said, hey, I've seen how the court works. I know that if they don't like what I'm putting in here, they're going to find one little technical thing, and then they're going to basically say, oh, no, the whole thing's no good, even though anyone with a brain would, instead of rescinding the entire law, they would just retract or they would excise one section of it that is unconstitutional. But if you don't like it, you can say, when I find something I don't like, do I want to throw out the entire law, or am I going to just carve out that part that's unfair and illegal? So the law specifically says the only remedy the court has here is you have to carve out that part. You can't attack the other parts. It is genius. And that's what I'm saying is I think that's what Nate and I think all three of you are really agreeing with here. At the same time, it is kind of scary because when you look at the ramifications, if this does hold muster, you can see states becoming very authoritarian and basically saying, we don't have to worry about the Constitution. We'll just find a financial incentive this way, a financial incentive that way, and basically pass whatever laws we want. They can outlaw. They can say anyone who uses the words Fauci juice laws together in a sentence is punishable. It's punishable by $5,000.
I'm going to sue you, and you can't get to me, and then Legalbytes will also sue you, and you can't sue her, stop her because I lost and everything. It's great,
right? Because then also, oh Nate, yeah, you've been trying to get in.
No, I'm just saying that the insanity about it is that, again, this is all perspective, right? If you live in a state like New York, I could see them tomorrow passing something like this and saying, if somebody has an illegal gun and they show you the gun and you're threatened with it, guess what? You can get a $10,000 fine and this, you can sue them. That's exactly what's going to happen, right? Because all those anti-abortion laws, you just take abortion off and put gun, then we're in New York. So this is I think a lot of people forget that as legal professionals, we don't look at this in isolation of this particular state. We look at it as something that can happen nationally. And the same thing with what we're struggling with now in terms of disinformation. If you say the wrong things, they'll kick you off YouTube. But now, just like Joe just said, if you say the wrong things, they may be able to say, okay, the government's not going to punish you. But now a private citizen can sue you for saying, guess what? Vaccines don't work, right? It gets to the point where we are making
my ears.
We're making the slippery slope argument, but I think this is where the slippery slope argument actually matters when you're talking about something that's constitutional across the nation.
I hate people saying slippery slope when it comes to law because we work on a precedential system. It's not so much slippery slope as precedent. Sorry to interrupt you, Legalbytes.
That's true.
No, I was going to say too, though, is that so then also there's I mean, where is the limit for how many times a person can be sued, right? Because if you have an unlimited number of individuals that can sue you under this new law, that means everyone in your entire city can jump on the train. As soon as they see that you're being sued by one person, then they can just scroll through public records and be like, oh, I'm going to sue this person too. I'm going to get my $10,000. I'll sue them too. I'll get my $10,000. Then like, where does the limit end up? And like I said, like I cannot understate the concern that regardless of, now remember that when you are filing a lawsuit against someone, you don't necessarily know that they have done the thing that you are alleging. So you can just file a lawsuit against someone, get all of their private medical records, allege under this law that they have done the thing that you're saying that they've done, and they have to give it up if it passes the pleading stage. You now have access to their private medical records, and like, as a woman, that concerns me because that would affect someone like me. So
it wouldn't even just be you, though. In theory, it wouldn't just be women, because in theory, if you want to take this law to its extreme, if someone alleges that I advised you to go get a procedure, I too can get sued. So that's why it has such broad ramifications, and it's intentionally, ridiculously broad, because I think they know that parts will be trimmed down, and I think that's, I mean, what's going to end up happening with this? I mean, I can't even begin to speculate how the courts are going to try and tackle this monster.
Yeah.
I think it's a fascinating case to watch, though.
You gotta hit the Constitution, because no matter what they're trying to do, they can't avoid Roe v. Well, actually, Planned Parenthood v. Casey, to be more precise, but they can't. They have to hit that issue, right?
I wish they would have. Don't you? I wish they would have gone after Roe v. Wade directly. They just would have said, you know what, we're going to pretend Roe v. Wade doesn't exist, and then see if they get the conservative court to reverse Roe v. Wade, because there's at least 2 or 3 voices there who are fine with overturning Roe v. Wade. So if they would have made it a criminal thing and then made it more direct and said, hey, you know what, let's see whether the court still believes that Roe v. Wade is actually the intellectual gospel that it's been hailed as by the left for the last 45 years. And test whether or not in today's climate and on the court that actually is the opinion of the majority of the justices.
But that only thing that does is I think makes it, because the principle of Roe v. Wade, as you're saying, is still enforced. But I think there's a problem, and that's the Louisiana. Remember when Louisiana did that whole criminalize it? As soon as Kavanaugh got put on the court, they criminalized abortion, and then it went up and it was struck right back down. Blah, blah, blah. So I think the court wants to do a chip away. And for those of you who don't know in the live chat, sometimes the court just doesn't want to overturn something right away. So they do this chip away method, where every time you get a case, it just chips a little bit more away. That happened in Brown versus Board of Education. There's like a whole bunch of cases before that just chipped away, and then eventually, hey, none of this works, right? We've been trying to chip at it all this time. None of this works. It's just a full overturning. And I think that's what this conservative court wants to do, is chip away. But I also think you have the issue is going to come in, is that how long is it going to take to chip away? Right? How long is it going to take? Because by time you keep chipping, and if you have a couple of more Supreme Court justices that get on there that's not, anti-Roe v. Wade, then all your chipping away goes for naught with one ruling that says, hey, we're going the other way. You know what I mean? So, how long does this court wait?
So let me fire back at all of you with a question here. We all have this concern about slippery slope, or as Kurt calls it, precedent. Is it not possible that we can look at certain constitutional rights as being super rights, so to speak? Really genuinely fundamental, fundamental. Yeah, the same way of super, and the court has used the term. I've seen,
at least Justice Amy Coney Barrett has.
Right.
I don't know if anyone else.
So if we attack Roe v. Wade in this method, that doesn't necessarily mean that your gun rights or your free speech rights. Certainly, I would say the First Amendment rights are going to be held inviolate. I feel confident that First Amendment rights are going to be held inviolate, but and probably Second Amendment as well. As far as these other rights, I think that they are more ripe for being hacked at, and we saw it. By the way, just to prove the point, we saw that the court has made a distinction between some rights and others, because when all those cases were being questioned as far as lockdowns and whether they were restrictive and whether they were unfair, we saw how the majority of the court in Roman Catholic versus Cuomo basically came down and said, no, you're not messing with First Amendment rights. And so they'd certainly look at certain parts of the Constitution as being holier than others, and I don't think they look at the penumbras as being that holy.
Right. I mean, there definitely is a hierarchy of constitutional rights. That's for sure. Sorry, Nate, go ahead.
No, I was saying I disagree with the church one, because that was a 5-4 decision. First it was 5-4 decision one way, then you got a new justice, it became 5-4 decision the other way. But I do think when it comes to a lot of these, because right now the battle in the court is how restrictive or how much power can the government have in an emergency situation to limit these rights. And in the last case for the eviction moratorium, the court sneakingly put one little line inside that decision that I think a lot of people miss, and that was the fundamental right to exclude from property. Mm-hmm. That's a fundamental right, and they put that in there, just one little line, because that's what that whole thing was about. Well, the landlords have the right to exclude, but think about this: for over a year, they allowed that fundamental right to exclude to be suppressed. Until then, they said, okay, now we've gone far enough. They can't. And then they even gave precedent to say, well, guess what? That fundamental right can even be suppressed even more if Congress chooses to do it. So I really think these rights are contextual. They're not absolute. And the reason why is because the court has to do it, case by case basis. In this case, your right to exclude, which the court says is fundamental, can be disregarded by executive action, even by legislative action. So again, I think it really depends on the people who are on the court and how they feel about whether these rights are as expansive as we want to make them seem, or if it can be restricted.
Yeah. So then considering keeping in mind the, I guess, slightly more recent Supreme Court opinions that have recognized certain private rights or certain constitutional rights that people have against other private individuals. So, for example, Hobby Lobby, for example, that's a private constitutional right, that you have against another individual. What do you guys think as to whether or not the standard of the constitutional right now, right to an abortion, do you think that this law violates it? Yes or no?
In spirit, yeah. I mean, it's trying to, yeah, very much so. I mean, if this were a state actor, you're there, no problem, without blinking an eye. So if the Attorney General was the one enforcing this, I mean, and you asked me to judge about it, strike it down so fast, you make your head spin, because the precedent is so clear. And then, but we have all these new complications. I don't know what to do with it. I did like the point about the private on private action with the restrictive covenants. So there might be some case law out there, which it wasn't in the decision from the district court that I reviewed last night, which was horrible. But there might be some other case law out there that might afford an opportunity for this private and private action to say, no, there's enough state action there to get at it. That might allow for you to try to do what you're trying to do. But it definitely violates the spirit of it. It's trying everything possible to get around it. And someone or some people in Texas or whatever put on the biggest thinking hat of all time to create this, to be like, well,
it definitely gets points for creativity.
It points for creativity. It's but then it's the implications of it. It's like you created, you've created the atomic bomb over here, and now we don't know what happens next.
It's a 10-gallon hat statute.
Yeah. I mean, it's so that because the standard right for a right to an abortion is you can't, the government cannot create an undue burden.
Magic words.
Yes. So that's why I mean, there and that does affect private individuals in some respects, even today, right? Because if you protest outside an abortion clinic, you have to stay outside of a certain amount of space, right? Because you're not you can't intimidate people that are going in to seek medical services, whether and abortion clinics, they also provide other medical services too. So
just one piece of it. Planned Parenthood v. Casey, where the undue burden doctrine originated from for abortions, they did have a piece in there about private parties. For instance, part of the law that was struck down was that a husband had to be notified that his wife was having an abortion.
Right.
And the court said that was an undue burden. And that was just between two private parties. One private
Yeah.
party had to inform another one. So the precedent is even here within, I think, the Roe v. Wade doctrine.
That's a good point.
That whole undue burden thing is so amorphous that that is, you want to talk about, a nuclear bomb or putting a weapon out there, which is like so dangerous. That when you're starting to get into the whole subjective question as to what's considered an undue burden,
Yep.
and you open that up there, it's like any judge can basically come up with whatever he wants and says this is an undue burden, that's not, and it all will depend on. Then I don't like laws which can very easily just vary from one courtroom to another in the same courthouse, depending on which judge you get. And that's when you have a real problem. It's like, oh my God, I pray I get a good judge for what we're looking for, because otherwise, I mean, it's just, that's not the way law is supposed to work. It offends my sensibilities about how the purpose of law.
I'm with you. I'm on an academic purity plane, the purity of it. And when you have, and we'll get to, I suppose, with Spears at some point, but when you have something like family law, and it's like best interests, I'm like, just end me now, because I can't deal with
that's
something
all
that,
of family law.
Yeah,
all of family law is best interest of the child.
I can't deal with something that floaty. I don't know how to deal with this. I don't want a piece of that nonsense. So.
You look at the 21 factors, baby. There's like,
oh yeah, that definitely is going to help, because there's no way with 21 factors. Every judge is definitely going to come out the exact same way, I'm sure.
Well, but that's also why appellate courts then come up with all kinds of tests and weighted factors and all that kind of stuff too. Though, I mean, why else would we have appellate courts, right?
That's the reason why we got jobs, because if the court said undue burden, and that gives me I go to the court and say, hey, this law right here is an undue burden. And let's just be honest too. This is just kind of a remake of the other laws that were struck down for the doctors, because this is really affecting the doctors. Right? You can sue the doctors who do the abortion, blah 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 blah. And this was, remember the admitting privileges laws that were going around that were so popular. Well, we're not banning abortions. We're just saying you have to have admitting privileges, and come to find out, no one can get admitting privileges, and that was struck down as an undue burden. That's the same thing's going to happen here. Hey, everyone have an abortion. So. No one can have an abortion. This is an undue burden. But again, the
doctors can't sue. No third party standing.
No, that doctors get third party standing. That's Roe v. Wade gives them. Well, not Roe.
Well, they're not under SB8. They don't.
Oh, but doctors get third party standing though, because this is like one of the foundational cases of third party standing. Doctors not being able to, right? I forget the name of the case. I think it's Flask or something like that. But doctors not being able to practice get third party standing. So
well, they'll sever out that part of the statute.
Probably.
Yeah, I think right about now, I guess I'm glad I'm not part of an appellate court, because I feel like if we're part of an appellate court, we'd be dealing with this forever, because we have to deal with it and strike down different parts and rewrite parts, and it just come back up again and again and again. So I guess what we'll be talking about for the rest of eternity. This is great.
Now we're going right to undue burden. This is an undue burden. Yes, okay, blah blah blah. I cite some First Amendment cases, Roe v. Wade, Planned Parenthood, and let the Supreme Court deal with it after that.
Yeah, no, I think Nate is right. I think that the way that this is likely going to result is that there's going to be an argument that similar to the previous cases having to do with housing between private parties, that there's going to be a similar argument here, and then I think as soon as that happens and they find that court action means government action, whether it's through injunctive relief or awarding damages, no matter what, they're gonna find that involves the government, and that therefore it's gonna be violating the 14th Amendment here.
That's pretty wrong. That's pretty wrong.
That's my prediction anyway.
Sorry, I had to get to the moral end of it, so I pray. I mean, yes, I can understand that. I can understand that conclusion, and there's legal basis to say it. It's logical, but you don't have to draw that conclusion. Ultimately, the other distinction to draw is what I was pushing on earlier. Is just sort of look at certain constitutionalities as being different from others. I mean, because the whole the whole logic behind Roe v. Wade. I don't know if you want to start getting into it. It's so aggravating to me.
If we're gonna go there, man, Roe versus Wade logically, man. Legalbytes, you want to defend it from first principles?
Defending Roe v. Wade.
Yeah.
Well, I mean, I don't know. I mean, I could take the Scalia approach and say it doesn't matter because stare decisis is stare decisis.
There you go.
Right.
There you go. That's a nice solution.
The Supreme
Stare
Court
decisis should never apply to the Supreme Court. It should never apply to the Supreme Court because the whole purpose of the court is that otherwise they can never overturn any law. We should still have Plessy v. Ferguson. We should. It's ridiculous. If I don't understand. Maybe one of you can explain it to me. I'm a lawyer. I've been practicing for 20 years now, and I'm gonna ask you, how is it that the Supreme Court can sometimes say stare decisis and other times say, well, we're overturning this law?
Well, so in order to overturn a decision, stare decisis would require that there is some sort of a change in circumstances, a change overall in the law or in the world around that law, right? So one example could be that if we were, one of my favorite subjects, of course, is Section 230, that if the Supreme Court decided to take a look at Section 230 and say, you know what? When that law was passed, the internet did not really exist. It was not a thing. And it wasn't, these companies were not that powerful. Now they are, and it's incredibly, concerning that the amount of power that they wield. All of these circumstances, the entire world is different. And so therefore, we are going to change the way that we are looking at this law. That would be an example of how the Supreme Court could overturn a prior ruling in keeping stare decisis intact.
I'll give you Justice O'Connor's answer from Casey versus Planned Parenthood. I thought Justice O'Connor had as good an answer as any. There's 4 factors you look to: whether it's become unworkable, whether it's become so undermined that it doesn't make sense anymore, and the other factors that she pointed to, I thought was a good answer. I think that saying stare decisis should never apply is a dangerous proposition. For example, Heller versus McDonald. If stare decisis is never a thing, then, at this moment you get 5 justices who think gun rights bad. They say, well, we're just going to issue a new decision that overturns Heller, no matter how well reasoned it is. I think you do overturn cases like Plessy because it's been shown to be unworkable, shown to be undermined by experience and so forth and so on. So I think the sort of standards now, although they are slightly floaty, they're not quite as floaty as family law, so I can make it work, at least in my own mind.
Fair enough.
So, yeah.
By the way,
good logic doesn't seem convinced.
I like all 3 of you. I'm not here to fight with you. I'm just.
Thank you.
I've been invited back.
I've had each of you on my stream at one time at least. So yeah, I'd be happy to take any of you back anytime. So. Yeah. Why would I want to alienate you? I noticed in the chat here someone was talking about my hat. So, and this is not just a random hat. This is an NYPD. If I can find it. And if you can zoom in there. Yeah. So this is a hat I bought a week ago when I was going to a rally about 2 words that I can't put together in a sentence on YouTube, and in New York City. And on my way down there, I was like, it's hot. I want to wear a hat. And I was down there, and so I bought this hat, and I knew right away the ramifications of it. On the way back home, I got on the subway and New Jersey Transit, and the rule there is apparently, it's an unwritten rule, that when you're traveling on New Jersey Transit, you have to be wearing one of 2 things. You have to either be wearing a mask, or you need to be wearing a $15 hat. Because if you're wearing a $15 hat, instead of being thrown off the way I was the first time, they come over to you and they look back at everyone, and the guy just glances at my ticket and just moves on by, just because I'm wearing a $15 hat. So now I will ask each of you, because I've looked into this, not to side verse because this is your show, but so that's why I wear the hat. So I'm going to ask you, I've looked into whether or not this is an issue of impersonating an officer. And this is not legal advice to any of you out there. I'm not giving you legal advice. So don't come say, Joe said, hey, all I need is a hat. I don't need a mask. But my question to you is, from what I've seen of impersonating the law in both New York and New Jersey, I don't know about Texas or other places, but I'm sure it's similar, that it's okay to dress in a police costume. It's what is a violation of the law and a misdemeanor level, at least in New York and New Jersey, is if you start receiving benefit from dressing in that manner. So now that I have three great minds here, great legal minds here, I'm going to ask you your thoughts as to whether that, seeing as police officers are required to follow the same rules as you and I, it's just not enforced, seemingly it's not enforced against them. Is that something that someone could be held liable for a misdemeanor here of impersonating an officer in the event that you're feeling pretty confident it's not going to be enforced, even though it technically is supposed to be enforced? So that's my question for you. You're my lawyers. Tell me, do I have to worry about just wearing this hat when I go on a train?
It seems to me, my friend, you're engaged in rank speculation as to why this person on the subway went right past you. You're just assuming it's the hat, where it could be for any number of other reasons they decide not to bother you. So I don't see a problem.
Beautiful. All right. Any of you legal bites? Lita, you want to weigh in here, or Nate? Nate's a New York lawyer, so I think he's the final say.
And he's a former police officer too, and former prosecutor. Right? So he is definitely the most say of anyone here.
So I haven't looked too in depth into this specific area of law.
I just threw this at it. I do
understand that a police officer costume is a thing. People can wear them. And not be prosecuted for it. It could even be deemed a form of expression at times. Especially if it's Halloween, maybe you want to make a statement.
Prurient.
Sure, we won't go any further down that road. But yeah, I did spend some time on Nick Recatta's live stream last night.
That was great.
So,
that was a great stream last night. I'm glad he finally had you. I kept telling him, get her on. She's a great guest. He's like, no. And finally, I twisted his arm and got him to I'm just kidding. I had no idea you were going to be there, but you guys did great work.
Yeah. No, it was great. I reached out to him and I was like, "Hey, I want to go on your show." And he's like, "Okay, cool." So he has some very, very fun and active viewers. I'll put it that way.
Yes, they're amazing.
So anyway, so we won't go down too much further down the prurient road, right? But there are all kinds of reasons why you might be wearing a police officer uniform, but I think that part of it would have to do with how much how realistic it looks, and then other circumstances around, like what it is that you're doing if you're going up to people and trying to arrest them. That would probably also have something to do with that analysis. But I think probably just wearing the hat on its own, probably not enough. For example, if I'm walking around wearing a Dodgers baseball cap, people probably would not think that I'm an actual Dodger on the team.
All right. So, Nate, just tell me. So you're the final say here. If I have to call you up and ask you to defend me for a charge of a misdemeanor for wearing this on the subway, so do you like our case here?
Court. Throw yourself in the mercy. No, you know what? It's funny. When these impersonation cases, when you deal with them, for instance, movie actors, stage plays, people wear police uniforms all the time and doing all these things. It's really not the uniform, but it's what you're trying to, are you trying to elicit some benefit, right? Me wearing a uniform on the subway, going through the turnstiles for free, people, would a reasonable person think that I was a police officer? I think Chris Rock has the best joke about it. He says that one time he was on the corner and he saw a woman dressed in a very, scantily clad. He looked at her and he said, "Hey, how you doing, miss?" And she said, "No, excuse me, just because I'm dressed like this doesn't mean you can assume that I'm, a prostitute." So then the next day he put on a police uniform, stood in that same corner, and then a woman was being accosted and she ran up to him, "Help, help, help." And he said, "Listen, ma'am, just because I'm dressed like this doesn't mean you can assume anything," right? So that's what it's really going to come down to. Wearing a hat, a badge, a patch, that's not enough. You really have to be showing, if you pulled out a badge and said, without even saying anything, and a person moved back, that's what you're looking for. That's something that's like, hold on, now you're impersonating an officer because the person is led to believe. But just wearing a hat,
Right.
I don't think you're, and that's not
Well,
even an 8-point hat. That's just
if any of you want a hat,
anyway.
Thank you so much. Thank you. You are my attorney now. If God forbid, if anything happens here, I will be calling you. You'll be my one phone call, and I will be selling these hats now on my channel. So, if anyone's interested, I happen to think that I'll tell you, the inspiration came because like 7 years or so ago. And maybe this was illegal what I was doing. I had a police hat, not this one, but I had a police hat, and we were stuck in traffic trying to get into into Lincoln Tunnel, and no one was moving, and no cars knew when to go. And I was like, "This is stupid." And I was wearing the hat anyway. I popped out of the car. The wife was driving. I walked 2 blocks down the road past all these stuck cars, and I just started directing them, saying, "You there, you there, you there." And I was helping traffic move. And ultimately, obviously, I expedited my own car forward. And once my car came forward, I popped in the car, and we just kept going. and and I felt like there was a benefit I was providing. People they see the hat. They see the hat, and all of a sudden they're like, and
the one thing I learned from all that kind of stuff is the magic of the clipboard.
yes,
Like if you have a clipboard, man, you
And a
can
lanyard.
walk into any business and just do
Yeah.
whatever the hell you want.
Oh,
Yeah, and don't forget the lanyard too.
Yeah,
Yeah.
the clip, it's like
yeah, but at the end of the day, it's all about intent, right? Can they prove your intent? And the way they're going to prove your intent is, where did you get any benefit? Were you trying to, fool people, that type of thing? Because if you don't have any intent to act like a police officer or, impersonate a police officer, they got nothing. They have to have the minimal intent.
I'm an officer of the court.
yes, you are. We're officers of the court in New York also. Not all
Yeah,
states are like that. Not all states are. I don't think all
Really?
states. I don't think
This is new information to me.
I didn't. I was not under the impression that all 50. I don't check the laws in all 50 states, but I was not. I was not.
You
I was
don't?
actually led to believe. Look, apparently Kurt is. He's like saying, "Oh, this is news to me." So I'm not. I was told that New York State conferred upon me the status of officer of the court, but someone had told me that is not the case in all states. Whether or not they were accurate, I don't know. Apparently, Kurt has looked at the laws of Iowa and Maine and Alaska and verified that every attorney admitted in any of those states is considered an officer of the court, and I defer to his significantly more infinite knowledge on this matter. So,
Fair enough.
Sounds good.
So
So-
let's on completely other topics. Legalbytes. Does anyone, do you or anyone in your household have any thoughts about recent international events, particularly
Oh,
involving
boy.
the Middle East of any variety?
Well, I can't speak to anyone else's opinion within the
Have
within the
opinions been
household.
shared with you that you would like to not tell us about?
I cannot speak to those because I would not want any sort of disagreements on certain opinions to be shared, and then to get back to that person or any other individuals.
That's respectful, of course.
Yeah, yeah, for sure. I wouldn't want to share those opinions of other people, but I mean, wasn't planning on talking about that specific
We
subject.
can move on. I just figured I'd poke the barrel as long as we're wrapping up.
I have no
as long
idea.
As we're here.
I don't even know what you guys are talking about. I don't even
I
know.
understand.
No, I know that, but apparently I don't know what opinions. Apparently there's some sort of sensitive opinions about Afghanistan out there. I thought this is like the one time the left and right have actually all come together and recognizing that, yeah, we probably should have gotten out of there. That's okay. And everything we did.
But never underestimate the ability of someone in the military to get in trouble for an opinion.
Oh, okay.
Regardless of whether it's universally accepted or not.
Okay. All right. Well.
Yeah. So I'm always super careful about that. But no, but I mean, but I guess we can probably move on to the other stuff that we were gonna talk about. So
The Britney Spears conservatorship.
Britney Spears conservatorship. Sure. It's the gift that keeps on giving. I know, Kurt, you said that you're not quite as up on this. But there was
it's the problem I was saying earlier. It's the question is what is in the best interest of the conservatee. I just throw up my hands and be like, what the hell am I supposed to do with this?
Well, yeah, I mean that's a question that is 100% up for debate, right? Because depending on who you're asking, what is in her best interests is and the question is in a case like this where someone's someone's competency or someone's capacity is in question, how much weight do you give that person saying what their best interest is? It's kind of a catch-22 sort of argument to have if you're looking at it objectively. If you ask someone who's part of the Free Britney movement, you know exactly what they're going to say, right? But if you ask someone from Britney Spears' immediate family, they'll say something exactly the opposite. But something that was interesting to me was that, so I guess sort of in the way of updates on this case, there was a supplemental petition to remove Jamie Spears that was filed by Britney's lawyer, and essentially it seemed to me personally that there was a lot of the same, but sort of just like rattling the saber again for this hearing that they have coming up on September 29th, basically saying that Jamie Spears has been taking money, that he only wants to step down only after he's taken more money from the estate. To answer the question here from Eldon Bannerling, didn't her father step down from the conservatorship? So that was a thing that made headlines recently. That people were reporting that he had agreed to step down, and he was saying, "Yes, I'm stepping down." That is half of the sentence that was in that particular paragraph in a particular filing. He said, "I agree to step down at some point in the future after all of these things have been resolved," which is like so many conditions that who knows exactly when he's going to say, "Okay, all of these conditions have been met. I can go away." So it's true, but it's not true that he said that he's
not true.
He's willing to step down. Essentially, not in the immediate future, not in the way that people think that he said that he is willing to
ever.
Yeah.
Okay, no. Yeah. I'll tell you. Yeah, you know what? When she turns 40 and she can't be monetized anymore, he'll be really happy to step down.
Yeah, that's. I mean, that is.
I mean, at 40, she probably can still be monetized. 50, he'll step down.
Yeah.
No, there does seem to be potentially, lest I say it, but some sort of financial motivation that maybe is more personal than in the best interest of Britney.
Yeah.
There's some suggestion along those lines.
Yeah, I mean, I can't understand that. So one of the things that he had said was, I'll step down after we've resolved this accounting issue, because there's a dispute as to a particular accounting for how much he's going to be paid in fees, how much his attorneys get paid in fees, and all that kind of stuff. So Britney's attorney has said, no, there's certain things are certain line items in there are disputed, and so he said. Jamie Spears has said, well, after this whole dispute has been resolved over these issues, then I'll step down and I'll walk away, and you can appoint somebody else. So on the one hand, I can understand that administratively, when you do hand over a conservatorship case to a new conservator, there's a lot of time and money that gets spent just to bring someone up to speed, especially when there's been a long history in that case. So administratively, like that is a lot of money that can be spent, especially if you're right in the middle of a particular dispute. On the other hand, I think it's perfectly reasonable to be totally suspicious of his motivation and his intent in trying to perhaps just sort of squeeze some more juice out of that lemon.
Okay, I think that running Britney's assets is probably very complex, far more detailed than you, me, or anyone we meet on a daily basis. Than running her affairs financially is probably very complex. Probably takes some time. At the same time, I think to myself, Cuomo was able to step down and resign, and he needed 2 weeks to transition there
for some reason.
So, yeah, and that's running.
A very valid point.
That's running the state of New York. So I think that might be a little more complex than Britney's personal affairs. And I mean, all joking aside, look, the person stepping in for Cuomo it was a lot more up to speed on things and didn't have to learn new things. Fine. But still, it shouldn't take more than 6 months maximum It really should be like a month, 2 months, 6 months maximum for anyone to get completely up to speed on knowing everything about Britney Spears' financial life since birth. So, saying that this is purely about a hunger for money and greed, and a guy who's willing to sell his daughter off to basically be his own personal slave.
I just want to say on a purely personal level, if this was being done to me, I'd be apoplectically pissed. And I can't even begin to imagine someone trying to control my ability, my fundamental ability to have children. Because she has this IUD that she can't take out. And how much would that piss you off, Legalbytes? I don't even begin to know. But it pisses me off.
No, you supposed to eat. You have food.
Nate.
I muted him.
Okay.
I got him.
That was.
No, it's all right. My daughter is begging for food to take and throwing food all around the house.
Oh no, that's how you get ants.
Eat the food. There you go. Good job.
Oh man, kids are fun. I definitely agree. I mean, I think that there are certainly questions that have been very much raised as to whether this goes beyond what a conservatorship should be doing for or to any individual. I think that right now the prevailing attitude towards conservatorships in general seems to be that they are abusive overall. And I would personally say that there are some people that should be in conservatorships because they will be abused by other people out in the world, right? So just because, somebody's under a conservatorship does not necessarily mean that they're being abused. And there are some people that absolutely should be. Whether or not Britney should be is obviously a very serious question, and I'm certainly glad that people are looking at it in depth at this point. So, but
something
the other
is just super feels like super old school, like 60 years ago, or more than that, maybe at this point, old school, where we're taking the woman into the insane asylum, because she's daring to express an opinion. It feels very old school, controlling.
You want to talk irreparable harm, just like that, an IUD, an unwanted IUD, that is the ultimate definition to me of irreparable harm. That is not something that could ever be financially compensated. That is a life-altering impact on her, and it's terrible. I mean, I feel so badly for her, but
But another interesting point in this is that also this week there was a petition that was filed for a media request for order restoring remote audio for the court proceedings. So I thought that was really interesting because it brings up this question now in a post-pandemic world where previously what had happened, and of course tons of courts around the country did this as well, that with the pandemic, they basically closed down in-person court proceedings and opened up Zoom court. That's how we have Lawyer Cat and all kinds of other fun things to talk about. But now with this particular court, what happened was there was a hearing on June 23rd, and that was the one where Britney addressed the court and she told everyone about the IUD, told everyone about all of her experiences and got everything off her chest to the world. And I think it's because, if I remember correctly, just before the hearing, there were some people that were able to get into the audio and were able to call in and were like shouting for Britney, I think. And so since that hearing, the court decided, nope, we're not going to have remote access to these hearings anymore. That's it. Goodbye. And
that's just bad management of whatever they're doing on their end. They should have the ability to mute all those people. Every line I've ever called in on has special access codes if you're an attorney to speak. So that's just bad management by the court. That's on them.
I've called into this particular court before for remote appearing by phone conference, right? And they have an operator system where they have somebody, you call in, you say, this is my case number, blah 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 blah. They say, okay, you're here, on time. We have you here, and please, put yourself on mute. And we'll put you on mute for a period of time too. And so, I mean, that's totally possible for management purposes. But the court's reasoning was, okay, well, at the same time, we no longer need social distancing, so technically people can come to the court to watch the legal proceeding if they want to. We have more seating here. And the question with this particular media request is that they are saying that this is a First Amendment right for people to be able to see the court proceedings, to see other people petitioning their government to for whatever, for transparency purposes, I should say.
Do you think that's a First Amendment right? I mean, you talk about the power to mute, by the way. I'm well acquainted with that, because usually when I'm a guest on live streams, my mic is muted most of the time until I'm like, hey, I have something to say. But no, where you're saying it's a right to peaceably assemble. What is the First Amendment violation in?
Because freedom of the press would be the operative one.
Freedom of the press.
Because they were framing it, I guess, as a right to observe and comment on legal proceedings.
Is there a fundamental right? Is freedom of press means the right to access?
And the case law.
Well, the trials are supposed to be public, right?
All criminal cases have to be constitutionally, but yeah.
There are a lot of cases which they don't allow the press in there. So and this does seem like it's probably covering a lot of matters of sensitive nature. So I'm not sure. It's not like this is the first time a court would ever close its doors and say we're not letting anyone in here. And
right.
So
that even happens at court too. Yeah, so at Supreme Court level, that happens.
And I don't even know what their access policy was beforehand with people being able to be in the courtroom, or because being physically in the courtroom is one thing, but being able to record it and all the rest of it—that's a whole
right. I mean, that's been throughout the pandemic, at least from what I have seen from some of these other hearings that have been on Zoom. They've said you're not allowed to record it, you're not allowed to stream it, you're not allowed to do any of these things, but you can sit and you can watch and you can listen. But as far as conservatorship cases, those, generally speaking, I don't know in a case like this where you've had where one of the parties is a person of superstar. I guess greater public interest.
She's objectively she's a superstar.
Yeah, of course. So, but generally speaking, in a conservatorship case like this, you can walk in and sit in on plenty of hearings, and I mean, because they just line them up one after another typically. But I don't know if in a case like this they would have set the hearing to a separate time and date so that no other cases are on the docket along with it.
I mean, the restriction to record. My introduction to Rudy Giuliani was from pictures of him that were portrait artists made from him in court with John Gotti, because they couldn't take a picture in the courtroom. So this is a very. It goes back at least 40 years. that. And I'm sure it goes back well before that restricting that type of access. And I don't see what the harm is to the court of letting the press in there without enabling them to record. So
well, and the question too then is I mean, let's assume that there is a First Amendment right? That these proceedings need to be open to the public, that they need to be able to have the media in there, even if they can't record, but they're allowed to be there. Does that mean that now that the courts have this capability to broadcast over Zoom, does that mean that they now have a duty to do so? That's an interesting question. What do you guys think?
Well, probably not, because if no other reason than the practical one, because the person determining the duty would presumably be the court. So there's that.
Yeah.
You're saying does the court have a duty to ask? I don't know. Ask the judge. Oh wait.
Yeah, it's sort of like almost like asking like a teacher whether or not there should be mandatory. There should be mandatory cameras in the classroom. It's like, what do you think the answer? What answer do you think they're going to come up with? Let's struggle. What are we predicting they're going to say here? So unless
that's a good
point. The same thing officers would say.
Yeah. Well, I mean, police didn't have a choice. That's the point. They had a statute which basically made them wear body cams and stuff like that, and dashboard cams.
They say they don't have a choice, and then you have those
They
situations
turn it
where,
off.
for some reason, like there's 13 officers on scene, and none of their body cameras were functioning that day. What are the odds?
Nate, what do you think?
About the body camera issue?
Well, about the whether in now that courts largely do have the technology to have their proceedings broadcast over Zoom, do you think that there's a possibility that a duty to do so could be imposed on them at some point?
I don't know. All right. So I'm thinking about this in two pieces. Number one, no one has a right to the Supreme Court, right? So essentially, you can't force them to do anything. And I'm trying to extend that to state courts. I know some states, like Florida, have the Sunshine Law, where all their proceedings are, you can watch the trial from beginning to end. I know some states have that, but other states don't. And I think in some instances, you just have issues like the Supreme Court recently had an issue with the national security one, where they had it on a certain floor. They didn't let no one knew what lawyers were going up there. Like, it was totally secret. That was a secret proceeding. You still got the FISA court, for instance, right? The FISA court absolutely is a secret court. So I don't know. I think it depends on the jurisdiction. I think at the federal level, I think absolutely you can keep them out. I think at the state level, it really depends on the state. And I think like states like Florida, that's not going to happen.
Yeah.
But states like New York, I think it's still going to happen.
Yeah. Oh, thanks for the super chat, Fatal System Error. Great content. Here's money. Thank you.
Do you guys
always appreciate it?
So here's you also mentioned we're going to talk about Elizabeth Holmes. I don't know. I assume we're done with Britney. I just felt like
let's do it.
Yeah, Britney's done.
Yeah, so I wanted to ask you guys, because they sang Elizabeth Holmes now, the CEO of Theranos, and I think a lot of your viewers may be too young to remember 2015. So, and the whole case with Theranos. So if you want to give them a background before we discuss it. So
yeah. So Theranos, for anyone that is not aware, Theranos was this tech startup out of Silicon Valley, started by Elizabeth Holmes. She was a Stanford student that decided to drop out of Stanford to start this company. She basically had this idea that testing your blood for all kinds of tests to see if you need to be diagnosed with, I don't know, all kinds of different ailments, we could say, that typically what's required is a ton of blood to be taken, right out of you. But she said, what if we can create a product where somebody can get tested with only a tiny drop of blood that's taken like a finger prick? And so she came up with this idea with a box where you put the blood in, and it drops your blood in tiny little drops, and then it diagnoses you with all kinds of different things, or it says you don't have certain ailments, but it would tell you all kinds of information about your blood. And so she got a ton of hype around this, and then she managed to convince a bunch of people from the State Department and former DoD generals like General Mattis. There was Henry Kissinger,
Bill Clinton.
Yeah, but these guys were on the board of the company, and Bill Clinton, Obama, then Vice President Biden was at one point he visited the facilities there, did a tour and everything. So all parts of the political spectrum, they were all kind of duped by her, and it wasn't even just political, because she got a bunch of very wealthy donors to donate a lot of money. Like, we are talking tens of millions of dollars, or maybe even up to $1 billion, maybe, I think. A ton of money, just like ungodly amounts of money to this project. And then a story came out showing that the wheels were starting to fall off of this plan. Patients were paying for services out of the project and expecting to get accurate blood tests from just a drop of blood within 4 hours of the pinprick. And yeah, I mean, it turns out that not only were they not accurate, but then they eventually were not even using this miracle box that they had come up with. They were using other equipment that they had purchased elsewhere to try to come up with, with the, so all
They
kinds of
basically
issues.
were, and they were also I think they were farming some of it out to third parties who were basically using traditional systems that have been used for like 100 years, and then claiming like, we got all these. And when they did try to use it, it didn't work, and they tried covering that up, and eventually the government came down on them for committing fraud and covering it up. And it's a big surprise to me that Joe Biden was on site there and didn't manage to pick up on fraud. You would have thought that, old Mr. Hawk there, he would have, if there's anything wrong going on there, he's the one who would have picked up on it. Yet somehow it got even past Joe Biden. Something got past Joe Biden. Who would have thunk it? So
he still sit there screaming that the U.S. women's soccer team is being exploited. So things get past.
Yeah. So the interesting thing is she was actually dating her at the time. She had a relationship with her partner in the business.
Yeah,
who
the
was
chief operating officer, Sunny Balwani.
Sunny Balwani, and now they're turning fingers on each other. And
now she has a relationship with like some trust fund kid, and they have a child together or some bullshit. It's like
she has a new relationship. Yeah, she has a new relationship now.
I don't know if she's married. I don't know.
I think she might
but
be.
They do have a child together.
Right. So they severed their trials. And the fascinating thing about this is, as all three of you know, when you have a defendant in a criminal case, they very, very rarely testify. And her counsel has said that they're expecting that she is probably going to end up testifying and blaming all of this on her partner.
Well, why not? Maybe one last con. Maybe she can pull one over on the jury. I mean, she pulled it over on everyone else. Why not give it a go, right?
She must be such a good salesman. She must be really good. She must be really good at it. And that's the type of person who if you're her lawyer, that's the type of person. That capacity is what you want on the stand.
Yeah.
Isn't that the Menendez defense? The brothers both pointed at each other. So the husband points at the wife points at the husband.
But that wasn't severed.
Didn't have charm though.
That wasn't, and they didn't. Well, they were actually. I think they were considered good looking in the '80s, like when they were like
they were good looking, but they didn't have the personality,
right?
That Holmes does. She is good looking and has personality.
Or the stare. She just doesn't blink.
But that defense was classic, though. It was my brother. He's a shooter. No, it's this. And the jury said, "Well, you know what? Both of you guys."
Yeah, but over there, here's the difference. There, it wasn't severed. They were joined together, so it's like they're just like, you know what? The jury's able to say, okay, screw both of you. But over here, you get a jury which is sympathetic with her. They'll be like, yeah, it is all his fault. Yeah. And then and she gets off, and then 6 months from now, he's going to be like, no, it was all her. And they'll be like, yeah, they can.
Joe, but the problem is you can't sever that trial, because if you do sever the trial, that actually gives that gives a better argument to the state, because then you'll have one prosecutor in one case saying he's the only thing and the other guy's blaming the thing. Then you got in the other case saying he's the only shooter. But now if you're in one trial, the prosecutor...
You're talking about Menendez? You're talking about Menendez?
Yeah, with the Menendez brothers.
No, I'm not saying it should have been severed. I'm not saying it should have been severed. I'm not speculating on that.
All right, because I was saying if they're both are in the same trial, then the prosecutor kind of has to choose which one was the shooter. And if the prosecutor doesn't know, that brings up the reasonable doubt. That's why they didn't sever the Menendez trial, even though it didn't work for them.
And what I'm saying is yes, you're right. And the severability over here is what's going to hurt the state. It makes it more difficult for the states. If they're both pointing fingers at each other in one courtroom, the jury can basically say, you know what, you're both con men, and we'll throw you both away. But when it's severed and the jury's only seeing one defendant, and they're not going to see Balwani till some other jury's going to see him in next January. So, this jury here is only fixating on her story and, her position when she's getting up there. I think she has a much better chance of surviving and getting off than the Menendez brothers had, because they were pointing at each other in front of the jury. Do you guys disagree with me that it definitely makes it more likely she'll succeed because it's severed than if they were pointing fingers at each other in the same courtroom?
I'm actually thinking it's the opposite way. All right, so in one instance, there's, let's say, for instance, let's say there's a gun case. There's one shooter, right? But there's two people. So there are two people in the house. Someone is shot and killed, and you have two people who technically be the shooter. If we're in trial together, the prosecutor has to figure out who was the shooter. Was it A? Was it B? So the prosecutor. So now, if both people are saying, "Well, John shot him" versus Kyle shot her, then that brings that reasonable doubt, right? Who actually shot her, right? But if you sever those trials, then the prosecutor could go in one court and say, this guy's the shooter, and while another prosecutor is in another courtroom saying, this guy's the shooter. And no matter what excuses they make, the other guy shot, the prosecutor could just hold on and say, no, well, he can say whatever he wants, but that's the shooter. He was in there, the person shot and dead, that person's the shooter. That's why I think if you, by separating the trial, you allow the prosecutor in her trial to say she's the person, the bad person, and then you allow the prosecutor in the other trial to say the other person's the bad person. But if the trials are together, they're not able to do that. The prosecutor's going to have to pick the bad guy.
The distinction, but the distinction between this and Menendez is you have one bullet that's being fired, or one gun that's being fired.
Correct.
So it's one incident, and we need to figure out, okay, who did it? Over here, you have fraud that's going on for years. And
they're also alleging conspiracy to commit fraud too. So you need two people for a conspiracy.
Yeah, that kills the Menendez defense, right? So you should talk about conspiracy.
Yeah,
right.
Yeah.
But we've been monopolizing, and Uncivil here has been itching to jump in. So.
I've been enjoying it. I just wonder. My only question is a question I asked Legalbytes before we started streaming, which is why are we not in a Madoff situation where Holmes is facing, forever in jail? I understand it's a maximum of 20 years under the charges that she's been making, despite having a fraud on the scale of several billions of dollars. So as large as Madoff's, but her charges aren't as extensive. So I'm not quite understanding how that all came together. She's obviously super guilty. And I kind of hope that the judge maxes her out because of all the many, many frauds that I just talked about. It's like, screw the sentencing guidelines. Let's push her to the limit of what the statute allows.
And to be clear, her fraud charges are, so there's two groups of people that she's considered to have defrauded, right? They've got the people that invested millions and millions of dollars in this company, and then there are the actual down the line customers who bought who bought services from Theranos, who had their fingers pricked to try to figure out if they might have some sort of a problem that could indicate that they have cancer, for example. Like these are very, very real consequences that these people could have had, aside from just the monetary, how much they paid for that particular test. So yeah.
Yeah,
this should be an interesting trial. If she testifies, it should be super interesting. Go ahead.
Yeah,
Nick. Yeah, that's the piece that's going to be the interesting part. But I think this is just a run of the mill. Again, and usually these fraud cases are paper cases, so you just see the paper. You just it gets really boring when you get into the details. So,
but that's what we really want the jury and we want the press in the recording to actually, so we can actually watch her testimony up there and see how compelling she is, and how convincing she is, or whether her tears look like they're crocodile tears when she talks about the abuse from her partner and how he dominated her and she had no will of her own, which is essentially which
is great source for women everywhere. It's like, I have no will of my own. I was unable to resist this. As the CEO of this $10 billion company. I was
a slave to him.
Just doing wonders for women everywhere over here.
All of these lawyers in the room, the fact that we know this early that she's going to get up and testify shows that the government's case has to be pretty strong. Because there's no way, if the government's case was any weaker than this, would you be even thinking about testifying? Look at OJ, for instance, with DNA. He didn't get up there and say a thing. So her case has to be pretty weak for them to say, we're preparing her to testify. I would be like, what?
Yeah, that's a good point. Although one of the main, I think one of the defenses that they might be bringing up is kind of this how this fits in the context of Silicon Valley in general. Because one interesting question I think is how does this compare to your average startup where you have an idea and you have maybe the beginnings of a particular startup, and you're going and trying to get investors to come in and give you money so that you can turn this idea into an actual reality. And one of the things that happens in Silicon Valley apparently is when people are trying to get investors like that, they tend to inflate a little bit, as to what the product is and what the outlook is. So the question is, at what point does that become actual fraud? And did Theranos, did Elizabeth Holmes and Theranos, did they do anything different than what anybody else does in Silicon Valley?
If that's what all Silicon Valley is doing, we're really in trouble. Because they're literally saying we're using system A, which is a new novel advanced system, and not using it. It's one thing to say this will work and then it fails. You know, that is a project. That's your classic failed joint venture arrangement, where it's like, okay, look, we want to try it. We're innovating. We're trying something new. And we're hoping it's work. Here's all the reasons we believe in it, and we really think it's going to work. And you keep pinching it. Everyone knows in the back of their minds, okay, this may not work. If the product just failed, that's one thing. For you to be misleading people as to how results are coming in and lying to them about that, and then farming it out and claiming, you know, and claiming that you're doing it, that is not. You're not even trying. You're not trying to develop a product. You're just trying to bring in to trick people into giving you money.
It does work. It does work. She said in interviews, you know, she said we never used external equipment or third-party equipment. We're always using our own stuff. They were in business. I know that's not true. I'm just
no, I know. I'm just peppering in against her statement.
There might be some lies. There might be some lies. Yeah, we were totally using only our own equipment, never anything else.
I thought Alita was saying everything you were saying was not true.
Oh yeah, no. Everything that Kurt is saying, I was watching some videos earlier about, you know, with some interviews by her, and yeah, she was saying that.
60 Minutes Australia did a pretty good piece on her recently.
Yes. That was one of the videos that I was watching on this. That was very, very good. And then there's also a number of documentaries, I think, on it that are just so enlightening.
If she ever writes a book of how to run the con, though, I'll definitely buy that.
She could actually make money that way.
Yeah, a legitimate business. Teach everyone else how to do it. Masterclass by Elizabeth Holmes.
Yes, you have to give credit to people who develop a skill, and she clearly is a great salesman. I mean, conman, but you have to give credit for her ability to, like, I'm impressed by people who have talents beyond what I think I have a capacity to do, and I don't think I could sell $10 billion worth of anything.
But it's selling hopes and dreams. That's essentially what she was selling, the hope and dream. And then when it was trying to be tested, the thing that's got her in trouble is because instead of her saying we're still processing, it's not working, she tried to make it seem like it did work, and that's the front piece to it.
Yeah. And she was making statements that were later proved to be demonstrably false. So there were actual people behind the scenes that were like, no, what she just said on camera is 100% false because I'm living the opposite life.
Did you see the interview with the whistleblower? It was like in a Google Talk or something like that. It was really interesting watching this guy.
There were a number of them though, right? There was one of them was one of the lab scientists, Erica Chung.
I saw a guy speak who, at least the way the interview was pitched was, he was the sole person to come forward and leak it, even though he had everything to lose, because apparently he came from fairly good background or money or something, and like his uncle dad was an investor. Something like that, yeah. That's the interview I saw.
Yeah, super interesting. But yeah, so they just started picking a jury the other day, I think day before yesterday, and it'll be really interesting to see what happens.
Who do you want on that jury if you have your druthers? Who's your ideal juror?
Wait, for the prosecution or the defense?
Oh, for the defense.
For the defense,
probably a bunch of men who simp.
Yeah.
Yes, old men. Definitely.
No, I'm thinking geeky. I'm thinking betas.
Oh yeah,
betas.
Some silicon
she's gonna
betas.
get up there on the stand. You want a whole bunch of beta men on. You want as many leftist beta men as you can find up there who are basically
take a look at the men that were on her board. They were all old white men.
Well, that's because she was trying to project.
Those were the simpiest of them all.
But
maybe they were con, but I don't know. But Alita makes a fair point too.
Yeah.
Basically, men is what we're going with here. We want lots of men.
Yeah.
Young, old, rich, poor men.
Probably someone who has not worked in Silicon Valley. so that they don't necessarily know to compare this case to your average Silicon Valley startup case. Because if they're close enough, they can start forming their own conclusions that haven't been placed there in front of them by the defense.
Who would you take, Nate? Nate.
I don't know. I want an uneducated juror. I want somebody who's probably a little less educated, because it's obviously going to be a technical trial, right? About money and this and this and this. I want somebody who is probably a little bit more emotional than a little bit more calculating. So accountants, for instance, would be out like immediately. Right? If you took, elementary school accounting, you're not on my jury, right? you're getting kicked off. And I would want. It's interesting because women judge women more harshly than men.
Yep.
So I want.
I think so.
Pretty much a more male jury. If I can get a younger male jury, I would like that. Typically, probably going to be more white than black, and the reason why is because I can have her dress up in pretty alluring clothes and look innocent and look nice, and because again, a lot of people don't understand the game is played all throughout the trial, right? The way you look, the way you talk, where you sit, all of that is played
Your
out
posture.
in the trial. Yeah, and to have someone who's there looking weak, looking put together, saying this is it's all about my husband, that's something you got to look the part. So that's that's the way I'll be playing it. I'll be playing it.
Who's the ideal juror for the prosecution? A bunch of women who've been cheated on?
A bunch of women that work in tech.
I would say for the prosecutors, I'm looking for people who are college educated, high levels of education, right? Who it's harder to pull the wool over their eyes, who are skeptical, but are somebody who's logical. I am looking for probably women who are working women, because the same thing that upsets women here about your man is telling you what to do is going to upset them too. No man tells me what to do. She's full of crap. That.
Yeah, the independent career woman who feels like she was able to accomplish on the own is not going to fall for this whole like you're dominated by this man.
And I would also look for men who are in that field, because obviously, and I would also look for minorities, because rich white people stealing money is let's send them up the creek. They've been stealing money from black people all this time. This is just another example.
Yeah,
I know people are probably going to be listening to me thinking, "Hey, Nate is so horrible," but this is the way the game. I'm sorry.
I
guys.
think black women are
can
lethal
ask
to her. I think black women are going to be lethal to her, and especially a well-educated black woman. They're going to look at her and they'll say like, "Okay, I'm the foreman now. Okay, I'm taking over here," because they'll smell the BS. They'll feel they feel the moral outrage about how she's shaming women, and I expect she's going to break down crying at some point on the stand. There, she's going to have an onion there and ready, or like a little knife that she can stab herself in the leg while she's like testifying, and I
expect her to play the new mom card too, because she recently had a baby.
Oh, she's supposed to be nursing. She's supposed to be nursing in the courtroom or practically or whatever.
Of course, yeah. That's if I'm her defense attorney, I want the baby crying in there.
I hadn't even considered the possibility she got pregnant and had a kid specifically as a defense strategy. I didn't even consider that possibility. Wow.
Yeah, I think there's a possibility that it was an oopsie, but there's also a very distinct possibility that was 100% planned.
The problem she'll already have had the belly. If you're gonna plead your belly, old school, you still have to be pregnant, right?
But then they also have to contend with the possibility of separating a new mom from her baby.
I think she's going to get that baby there in court with her. It's so new. I think she's going to have that baby standing there. That way they can all see her in her mom role and crying about how she just wants to be able to take care of her children and take care of her family. And maybe that's how she figures that. Maybe that's how the defense figures they'll deal with the female jurors. They'll figure that that's something they can relate to and be sympathetic with.
I would absolutely have the baby there, and I would make it so every time we get up for recess, the first thing she does is gets up and goes to the baby.
Oh yeah.
I think that while they're testifying, I think she's gonna be holding the baby there. She's gonna be like sitting there.
I don't think
we'll go that far. But
The baby's only like 2 months old at this point, 1 month, 2 months old. So I mean, there could be a substantial amount of rocking that needs to happen over the course of a trial, right? So
lethal.
That scene, she's getting up every, but it's got to be every recess, because you want the people going back to that jury room saying, This is such a great mom. Every time the court stopped, she ran right to the baby. How can we separate this mom from this baby? That's the plan I would be putting in place. Listen,
She's using her baby in the con, man. This is the greatest con woman of the world. She's great.
Yeah, she definitely. It's coming. Oh, I hope this trial is on TV. I want to watch this woman work. You have to appreciate the master. Appreciate it. Don't just. It's hard for me to just look at her with disgust when I'm just sitting there in awe of who she. Yeah.
Please teach me this. How the hell are you doing this, man?
Yeah.
Well, we know how she's doing it, but it's the performance. It's like going to a movie. It's like you're doing it for the performance.
It definitely is fascinating to study, and then to also take a step back and be like, would I be convinced by this? And to really try to think of it objectively.
Oh, hell yes. I think each of us would be conned. Yeah.
Probably.
They're conning, as you point out, they're conning people who are like Perry and stuff like that to sit on the board. It's say that we wouldn't be conned. We'd be the smart ones. We're totally screwed.
Yeah. And that is human nature, though, to assume that you're beyond.
No, we're fucked. We're totally screwed.
But okay. So
it's easiest to con the people who think they can't be conned. Those are the easiest people to con. We just kind of sad.
That's true.
Yeah. Agreed. So anyway, well, that'll be an interesting one to keep track of. But I guess on that note, I have nothing else to discuss unless you guys want to bring up anything else before we head out.
Do you guys want to buy a hat? So.
I know there have been some comments in there saying that I need to be wearing a hat.
I'm not even kidding. Right after I finish this, I'm going right over to my thing and saying about Teespring to sell NYPD hats, Boston PD hats. I'm going to be basically have every city out there. You want one? You're going to be trading that 10-gallon hat of yours there. Oh, you're in Texas. They let you do whatever you want there. You don't have to worry about it. So I have to worry about. I think about the Northeast states.
We're constitutional carry now in Texas as of yesterday, so that's nice.
Interesting.
That's
right. That's right. And just make sure you don't get your women pregnant, because otherwise.
Well, I'll say this. Because you're gonna face a $10,000 fine. But
no, you're not gonna face. What I'm saying is you're not gonna be able to get. She's gonna.
Or get a $10,000 fine.
Right.
Hey, baby, take care of that. You told me to take care of the baby.
Yeah.
We're taking you to court. It's a minimum of $10,000 fine. It's a dangerous game. But I will say though, for those of you who think the Texas abortion law is a great thing, wait till when they get the gun laws, because when they flip at the gun laws and make these same exact arguments, you're going to be saying this is unconstitutional.
Fundamental right. It's a fundamental right.
Yeah. And with all due respect to Good Logic's much earlier point about the hierarchy of things, it's like the right to an abortion is sadly much more well established in law than the right to have a firearm.
No, okay. There's been more case law on it. Yes, there's been
a lot more case law.
That's true. But it gets attacked a lot more. And as far as
I think you're right about that.
They've had an opportunity to establish precedents.
But that's the reason why is because it's not in there. It's fugazi. I hate to say it, but it's just made up. The right to privacy made up.
Is a fugazi.
It's fugazi. It's not in there. You got this right, so we'll do it. You got this right.
You do
it. but it's constitutional.
So So anyway, that'll be another interesting one to see, because for sure there's going to be a number of lawsuits filed if they haven't already been filed for the SB8 law, and I'm certain that we'll see that sooner rather than later reach its way up to the Supreme Court. But that'll be, I'm personally troubled by the new law. I think that it's very fuzzy in a lot of ways. Enforcement of it is strange, and but it's very creative and very interesting to analyze, we can say. But anyway, that's about it. Those are my thoughts. Anybody else have any last thoughts before we head out?
Thank you so much for having us.
Yeah. Oh yeah. And everybody, go check out everybody's channels too. Check out Uncivil Law. Check out Good Logic. Check out Nate the Lawyer. Be sure to like the video if you haven't already. If you do, Indy will love you forever. She's sleeping right now, but she will love you forever.
Take care,
yeah.
everybody.
Take care.
Yeah.
Bye.
Ciao.
Alrighty. See you guys.
Godspeed.